think unless anybody's got any burning questions for David, maybe we'll have Marilyn explain the other three, and then we'll entertain questions about all three of them, or the process, or what the likelihood that the other three will get on the ballot, if that's okay. Is that okay with everybody?
Sounds good.
Okay, Marilyn, it's all yours.
Hello, my name is Marilyn Rodruguez. I am the owner and founder of Creosote Partners. We're a progressive issue advocacy firm here in Arizona that lobbies at the Arizona State Legislature and some cities. We represent the Smart and Safe campaign for adult use recreational marijuana. We represent the Second Chances campaign, as well as Healthcare Rising, the Stop Surprise Billing Act. So I'm going to start with, because I have it up in front of me, the Smart and Safe on the legalization of adult use recreational marijuana, and then we'll go from there. So can everyone hear me? Thumbs up? Okay, great. Thank you for having us today. So the basis of Smart and Safe, really I think of it as one of two criminal justice reform measures or that will potentially be on the ballot. We're, like Representative Powers-Hanley said, we're in active litigation. Every single initiative is in litigation, and Invest in Ed was the first decision, and we are so thrilled with the decision, and I will kind of be the counter to David. I was very pessimistic given the Supreme Court, and was very surprised and super glad that we prevailed. So congratulations to David. We're so excited to support that initiative. So the other three were all also challenged on the 100-word summary. And we'll know in the next couple of days, very likely, what the results are there. The meat, and I'll go very quickly through what the initiative does, but of course we have time at the end for questions, so please write those down. The meat of the marijuana initiative is to remedy a field policy. Arizona is an outlier. We're the only state in the nation to still charge felonies for any level of possession of marijuana. Of course, we have our Medical Marijuana Act, where there are some folks yes, please feel free to put questions in the chat to keep track of them. We have a Medical Marijuana Act, which of course we have some medical cannabis patients, but even they very recently, thanks to some county attorneys, particularly Polk up in Yavapai, but we also saw it with Lowell down in Pima, pursued criminal penalties against them as well. So that, and for so many other reasons related to the collateral consequences that come with a felony conviction, not being able to vote, serve on a jury, work in certain professions, or finding a job, is a big reason why my firm and many of my clients support in the progressive community the adult use recreational marijuana initiative. And so let me pull up my notes on the bullet points of what it does. Give me a second. So I'll just break it down to 6 very basic points. Again, I can go a little bit deeper. But first, it allows a person who is at least 21 years of age to lawfully possess and use 1 ounce or less of marijuana, including not more than 5 grams of marijuana concentrate, as well as up to 6 marijuana plants at the person's primary residence. It also, for a person under 21 years of age, reduces the penalties for unlawful use of marijuana to a civil penalty for the first violation, a petty offense for the second violation, and a class 1 misdemeanor for subsequent violations. This is for folks, again, under the age of 21, who today face felonies, who in the future would have potentially faced felonies, and we wanted to create a step-ladder system where, you know, on the first violation, it's a petty offense, right? You have an ability to remedy your behavior and not end up in prison for basic possession. Third, in addition to the sales tax that we are imposing, it imposes a 16% excise tax on the retail sale of marijuana and marijuana products. Fourth, it transfers $45 million from the Medical Marijuana Fund for a variety of different programs and purposes, including the Arizona Teachers Academy, public health, traffic enforcement, education related to legalizing marijuana, expunging certain criminal records, and implementing a social equity ownership program. Now, I want to jump to number 5, the expungement section. is a big one. Folks in Arizona are probably unaware, or maybe are sore and aware at the fact that if you have a misdemeanor or felony on your record, we have no path to expunging that. It is forever on your record. And so at least in the context of marijuana legalization and possession, we wanted to make sure that if you have this on your record and this passes, if it would have been found legal under this act, then you have a right to petition the court to expunge your record. We include money in there as well for community organizations and nonprofits to provide you with the legal support to go ahead and pursue those expungements, because the courts can be a little bit challenging to navigate, and we didn't want to create a system where those with privilege and the means to pursue expungements could, and those without could not. Last, and this is a longer one, we direct monies from the licensing and renewal fees, application fees, civil penalties, excise taxes, and penalties related to selling and testing marijuana, that they be deposited in the Smart and Safe Arizona Fund. And this fund is ongoing. Monies in that fund would be first used to pay the cost of implementing and administering and enforcing the measure. There's a lot of administrative burden that comes with creating a entirely new structure of the regulation of this product. And then if monies remain in the Smart and Safe Fund, the monies would be allocated to community college districts and provisional community colleges, municipal police and fire personnel, and the Arizona Highway User Revenue Fund, and also various justice reinvestment programs. For those of you in Pima County, if you're familiar with like Flowers and Bullets, for instance, that's a community investment program. Lucha, any church programs, but it's not limited to that. It could be public and behavioral health organizations, including substance use and prevention and treatment, restorative justice, jail diversion, workforce development, industry-specific technical assistance or mentoring service for economically disadvantaged persons and communities disproportionately impacted by high rates of incarceration, and for reducing drug-related arrests in the prison population in the state. Really, this part is one I want to make sure folks understand well. Is what we have done is we have taken the proceeds from the sale of marijuana, and we have said it can't just go to the general fund, though some of it will go to general fund purposes. We wanted to make sure that we truly put in funds for an evidence-based approach to front-end interventions in every part of the state it's called justice reinvestment, to ensure that there are programs in the community to help people divert away from the behaviors that might end them up in incarceration. So often we find that it is the system that failed the person and not the other way around. I'm going to stop there because I just dumped quite a bit on you, and I'll move to an update on the litigation. But first, Representative Powers-Hanley, was there anything you wanted to interject with?
Do you see Deborah's question down there about people who are in jail right now? I think that's a good one to answer now before you get into the other details, perhaps.
Sure. So people in jail now, unfortunately, we did not have a mechanism to make this retroactive to relitigate their sentences. And often folks currently in jail for marijuana possession, a very, very low number of them, in fact, I don't know of a single case, are there for mere marijuana possession. They're usually there for possession with intent to sell. And we're getting a little bit in the weeds, and I'm happy to do that. But because we're raising the threshold amount on what it can be legally possessed, you're going to see a lot less of that. In drafting this legislation, we actually called your Pima County Public Defender's Office, the Maricopa County Public Defender's Office. Actually, every public defender's office was invited to help us craft this language. Because I know in my advocacy on criminal justice reform, you often see law enforcement charge people with possession with intent for residual amounts, or if you have like a kitchen scale in your house and they find you with marijuana, they will say, this is clearly an intent to sell. You had a kitchen scale and we are charging you with possession with intent to sell. So unfortunately, because we are redefining the thresholds and what possession with intent means, this would not apply to people who are currently sentenced. And I wish that we had a remedy for that. We worked with the ACLU and the defense bar and the public defenders, but there was no path that we could find that would actually capture the folks who would have fallen under this threshold and shouldn't have been charged with possession with intent to sell. If that helps. It's very frustrating, but this is a very complicated nest to untangle. Another issue is because the threshold quantities that distinguish between a person who is merely possessing versus possession with intent. And so, possession is usually charged the size of a penny, right? Anything above the size of a penny, you are assumed to be in possession with intent to sell. But even if you have the penny and you have like a plastic baggie, that's transport. If you have a kitchen scale, that's intent to sell. They would always find, we have found in every case that has been brought to me and in my advocacy, a reason to charge you with the higher charge, because that results in a felony and they don't have to invest in diversion programs. And so, of course, this changes that and then redirects funds to diversion programs and front-end intervention. But another problem that we found, and this is why we had to draft the expungement provisions in the way that we did, is because the threshold was so low, law enforcement never writes down the quantity possessed on your charging paperwork and on your arrest paperwork. It's very rare for the quantity to be written down. So we turned expungement on its head and said, unless the court can prove that you had possession of marijuana in excess of the amount that we are making legal, then they shall provide you with an expunged record. And we hope, and in working with the ACLU and our public defenders, we hope that will have the impact of folks not having to go back and find their charging paperwork and being dismissed for expungement because they didn't think 20 years ago or 15 years ago or 5 years ago or even recently to check to make sure that the amount was written down on their charging paperwork. That's absurd. So I hope that answers that question. And I'm sorry, I'm having a hard time keeping track of questions and my notes. So if there's another one you want to throw at me, please let me know.
I think that was the primary one in there. Greer wants a fact sheet of talking points, which I'm sure you guys will have for all of us. So
yes, I can send that along because there's so much in here. It's 17 pages long. I didn't even get into the licensing piece, and I can definitely send all that information, but I think in the interest of time, I'm going to stop there. Oh, the legal challenge. Thank you, Greer. Smart and Safe is subject to a legal challenge on the 100-word summary, similar to what Invest in Ed faced. In the 2018 Invest in Ed decision, the court in essence said that you as a ballot initiative can be tossed if someone takes you to court over confusion over the verbiage. Now, of course, that case law is being developed right now, even as we speak. Today, we had the decision in Invest in Ed 2020. We don't have the opinion yet, so it's hard to say what the new standard will be. Or whether there will be a new standard, but I maintain that it is quite vague and potentially, or impossible to meet, because you can go through the process of gathering all these signatures and spending all of these resources and doing everything right and complying with every bit of the law to a T, but somebody can come to the court and say, well, I think that's confusing. And if the judge happens to agree with them, then everything you've done is thrown out. And so I was very, very happy to see the unanimous decision in opposition to that very thing happening to Invest in Ed. But the same thing is, of course, for different words happening to the Smart and Safe initiative. And so we are done with oral arguments and we are awaiting the decision we expect sometime this week. And thanks to the Invest in Ed decision, I'm going into that a little less cynically than I was before.